Good morning, everyone, and welcome to this learning journey covering contracting and negotiation. You will see on the heading, I tried to put down basically what we plan to cover is the linkages between the procurement process, contracting, negotiation. Now, the procurement process you know very well. You get the needs, and then you basically translate the needs through the solicitation process. Some people may call it a bidding process, like RFQ, RFP, ITB. Through the solicitation process, you try to come up, okay, so and so are the best suppliers. And then when you're trying to form the contract, so that means the contract cannot be done in isolation without knowing the whole chain. So keep in mind, preparation of a contract is not a standalone activity. If I have to prepare somebody's contract, I have to draft the contract, I have to understand the needs, I have to understand the solicitation process, I have to understand your risks around before I help you in drafting the contract. So contracting, I would put it this way, it is a linkage between procurement process. So that means it basically links the procurement process from beginning from the needs till the contracts are formed. Then some of you may be thinking, what is the role of negotiation? You can't sign a contract. You have gone through it, you have drafted it, now you're going to negotiate. So negotiation becomes a part of the contracting. So in short, I would call negotiation is also an integral part of contract. Let me summarize. Contracting is an integral part of the procurement and supply chain process. On the other side, when I say negotiation, negotiation is an integral part of the contract. That means when I'm trying to sign the contract, I cannot go ahead without going through the steps. That means I'm very clear, the price I'm getting is very good, the delivery is good, the risks have been mitigated, then I draft the contract. So you start the process, you negotiate, and then you draft the contract. So what we will try to do today is the focus would be, keeping in mind the timing, the focus would be on contract formations, how to form the contract, how to ensure the performance of the contract. And during the performance, there could be breaches. There's a breach, there has to be a remedy. For every breach, there has to be a remedy. Then we'll be following this with the subject on negotiation. Well, friend, with this, I move to the agenda items. Now, agenda for today's is the formation of the contract. What are the elements of the contract? Contract formation steps. If I have to say the contract is formed or not legally, what are the steps? From step 1 to step Z. Understanding each and terms and condition. We shortly call T&C. The performance of the contract. You have signed a contract, naturally you expect the performance to be best. But you also know very well there are breaches for many reasons. Sometimes it is beyond the control of the supplier. Sometimes it could be financial issues. Sometimes you're not given the complete details to the person. So then for each breach, there's a remedies. So understand around the breach requires a remedy. The next step comes that you have a remedies, but you're not happy with that. And the guy is not even willing to give you any remedies around. In those situations, you go with the dispute resolution. Now, dispute resolution is a legal path. You all know very well the legal path is a very long, time-consuming. People want alternate dispute resolution, ADR we call it. And the ADR could have mediations, we could have negotiation of someone's, or we could have arbitrations, which is the most popular nowadays. With many of the MNCs, arbitration is the most popular one. Then we'll also talk about what contract law will apply. Will the contract law of India will apply? India's contract law dates back to 1872, during the British time. Although there has been many amendments, I'm not questioning, but still it is called Contract Law 1872. So next is, we have gone through this. The negotiation, as I said to you in the beginning, is also an integral part of the contracting. So we'll talk about different philosophies. Most of you are conversant, the win-win philosophy, win-lose philosophy, lose-win philosophy, lose-lose philosophy. There are many. So depending on the philosophy, depending on the solicitation process, what you've gone through, there are strategies. So strategy is my game plan. Then there are tactics. The tactics is maneuvering, how I convince the guy, how I manage it. So how do we look at the body language of someone? So that's what we're going to talk about. So in the next 1 hour, I plan to walk through with you all these issues around. I know agenda is big. I'll try to be short, but if you have any question later on, you can certainly welcome to come back. Let's say introduction part, I think I already have told you what I explained in the upfront. Contracting is an integral part of the procurement. And this, the process of procurement starts from needs up to solicitation process and building contract. And then what we are focusing is building the contract. Now the definition of a contract. I think this is very crucial than any other slides I would call it out. We use different terms in a day-to-day terms. Oh, I have gone into agreement with someone. I have made a contract. You have made a contract, but is contract a contract? There's also a question mark. Is the contract a contract? So there has to be proper steps involved or not. If not, the contract may not be a contract. You might be calling a contract because you use the format of a contract, but it may not be a legally enforceable. Purchase order, letter of intent you give some time. You get into an understanding. You must have seen many diplomatic people when they travel from one country to another country. They make an understanding. As a buyer, you might be making some understanding. So all these different terms, at the end of the day, are they legally enforceable contract or not? This is what we are going to talk about. So elements of the contracts are, the very first you have to keep in mind, if you want this to be legally enforceable, there has to be an offer. There has to be an acceptance. Offer is the issue now, it's the very starting point. Who makes the offer? Is the supplier making offer to you? Is the buyer making the offer? If supplier is giving offer to you, supplier might be having his own terms and conditions. And if you are accepting the supplier offer, so in short, their terms and conditions are going to be overriding. I know none of us reads because when the supplier is giving you, they have got a sales condition, which in a very small font size, none of us reads. And if you accept it, in tomorrow there's a dispute, whose terms and condition will apply. So as a buyer, you want to protect the organization, you will say, guys, I will make offer. Let supplier accept it. So this is where it goes on. And sometimes what you do, you give an offer, supplier says, sorry, I'm not happy with this. I want the payment term to be changed. I want my milestone to be changed. That's what we call. Any change is basically a counter offer. Keep that factor in mind. Only offer is acceptance can be done once it's a mirror image, no if and buts, no comma and dots. Otherwise, it's a battle of forms. You send a form, other guy makes minor change. It may be typos. It's a battle of forms. And the battle of forms will be leading to counter offers. Now, when it comes to acknowledgement of offer and acceptance, which we call as an acceptance, is acknowledgement. It could be in writing, could be electronically, could be by conduct. So there are many ways to do the acknowledgement. Next comes consideration. Now, consideration is I give you something, you give me something. There's exchange of values. There has to be values. Value does not mean money. You do the work for me, I'll pay you so much. Yes, it's a consideration. So consideration could be in the form of money. Consideration could be in the form of a goods. Okay guys, you do this, I'll give you my watch to you. Is also consideration. So consideration could be that, okay, you do my work, I'll try to help you in getting this. It's in form of a service, I'm giving consideration to you. So considerations can be in form of money, which is a normal tool when as a procurement person, could be in the form of goods, could be in the form of service. The next thing which you have to look in the elements of a contract to be legally enforceable is the competent parties. Are the parties competent? One guy may be minor. The guy may be mentally unhealthy, not fit. The guy is drunk, intoxicated. Or it could be even under the threat sometimes. So that becomes not the competent parties. The next comes the legality of the purpose. You can't form contract for everything. Some contracts cannot be formed because legally they are not allowed. Somebody wants to deal with ammunition. Somebody wants to deal with drugs. You all know very well legally they are not allowed. So those type of contracts cannot be enforced in the court of law. Now contract formation steps. I hope by now you have understood the key elements. Let me walk through with you each element again. The very first, offer. An offer can be formulated. The first step for any party is to make an offer. So which is a promise by the maker to enter into a contract under certain conditions. The person who gives the offer is called offeror. Some people call promiser. And the one who is accepting is called offeree. Just understand the terminology as well. Sometimes we send catalog, prices. Somebody sends a catalog to you and you say, okay, I want this. Supplier does not give you. Can you take the guy to the court? No. It is just an invitation to you. You go to the department store, something is being displayed. You can't say, okay, this is an offer, now I accept you and give me this. So keep in mind those things, the catalog, the price sheet, the window shoppings, whatever you see around is considered as offer to sell, is an offer to sell, but just an invitation. It's not considered an offer to sell, but just an invitation. They want to attract you. Guys, come. See my catalog, looks beautiful. Price is good. Come down. But whether the contract, the guy will come into that or not. Similarly, when you issue the RFQ, you issue the RFP, and there are hundreds of suppliers looking at it. It does not mean that you're giving an offer to buy. So keep that factor in mind. The next comes procuring entity. As I said to you, it could be an offeror or offeree. So I would appreciate normally, because you have to protect your terms and conditions. You have to protect all the risk of the organization. Try to be the procurement entity, be an offerer, not offeree. So try to be an offerer. So if somebody has given offer quotations to you, fine, great. You take that content, but put down into your purchase order, explaining such a way that you are the one offerer and expect others to accept it. Now keep in mind, offer may lapse. Somebody has given to you offer, guys, my offer is valid for next days. I give you 50% discount if you place the order within 24 hours. And if you don't come within 24 hours, offer has gone. Then offer might be rejected. For some. It could be accepted as it is, or you may come with a counter offer. So there are 4 choices around. Either the offer you're not interested, it has lapsed. You reject it, say, guys, I'm not happy with this pricing. Or you accept it. Or you go back to the offerer guys, okay, I'm willing to work with you. If you can make this paragraph change, this terms change, I will be happy. Now, the termination of offers can also happen. Offer is not lifetime. There's a lapse could happen, rejections, counter offer, and sometimes you could revoke back also. You say, guys, okay, now the time is over, but I'm revoking it as a special case for you. So you could revoke it. Now, coming back to the next step. So, offer, I hope everybody understood what is offer. Now, acceptance of the offer. Now, here only I would say around offer could be again in a bilateral form. Acceptance. An offer that looks like a promise in return results in a bilateral contract. Somebody gives to you offer, guys, okay, please acknowledge it and send me before we enter into it. Sometimes people give offer and they don't expect any acceptance from you. Like in the, as you know very well, in ISM, we come out every week quiz test. We say those who get the best scores, we give them free ISM-INDIA membership. It is given to all. It's a unilateral. It's not bilateral. That means ISM is giving as a unilateral basis to you guys. Those who pass the quiz, they are entitled for this. They are not sent us any acceptance letter to us. So these are the one we call as unilateral contract. Anybody who does it in a week's time, the time frame is there, they get that benefit. Under the common law, because basically the British system is under the common law, Indian system is also under the common law, American system is also under the common law. And acceptance is valid only when it is a mirror image of the offer. So whatever offer was there, if you accept it as it is, and even if acceptance has not happened, as I said to you in the case of unilateral contract, not the bilateral contract, acceptance has not happened, but the guy has followed the terms and then demand for the results. The counter offer is a rejection of the original offer. So as I said to you, any comma, dot, any change is a counter offer. Now contract can be by conduct. You have sent the offer to someone, you have sent the purchase order to someone. The guy has not sent the acknowledgement, you know very well, 80% time nobody acknowledges. They start working on it with the good spirit of conduct. The job is completed. So contract by conduct also happens. Timing of the contract. So if there's a timing set down, that also the guys, okay, if we don't hear from you, we'll assume that you are accepting it. So you put down the timing frame. Now come the next is, as I said to you in the beginning, offer and acceptance is nothing but meeting of the minds. So mutual assent, when I talk around, both parties must exhibit a contractual intent. Contractual intent should not be just as a joke. Sometimes words may be spoken in jest or frustration. You are fed up. Your boss is after you. You are frustrated around. You say, guys, nobody else is listening to me. Then under frustration, jest will lack the requisite intent. I know it's a very easy to write here. How do we know whether contractual intent was there? Why the intent given on the jest basis or frustration basis? So I know proving is not easy, but that's a broad framework around. The terms of the offer must be clear and definite. Acceptance must be clearly communicated. Next comes oral versus writing. Here I would say in one word, for low values I can understand you can go into the oral contract, but keep in mind what we say, how people understand, how people interpret. Many people are from different cultural background, and particularly when you're dealing with overseas people, understanding could be different. So my request to you would be everything should be in writing. Even if you've done the job, tell the guy, okay, we have gone through it, looks okay, we'll be coming back to you within 24 hours. So writing is always better, because when you try to write down, the clarity of thoughts comes in. When you say verbally, you cut down so many words, and in the process, the other guy interprets in a different fashion. So try to put everything in writing. I think it also clears your process of thought, your mental process, what you are looking for. What makes a contract enforceable? I think we have discussed quite a lot, so I can skip this, I think. Offer must be made from the offerer, offeree, consideration, mutually between the party, capacity of both the party, and legality. Now, contract terms and conditions. Now, when we talk of contract terms and conditions, sometimes each organization has got their own terms and conditions. These are called boilerplate, like in a production shop. Sometimes even we don't look at it. They say, oh, what are your standard templates? Connect with the purchase order, connect with the contract, put them as an annex. People even don't read it. But sometimes when you want to overrule those, okay, you can't change them. You have to go to the legal units, get them cleared. But in case you want to change, then you can come with the special conditions. And those special conditions could be overriding particular clause if you want to talk about. These are broadly, let me tell you, I'll go through quickly with each one. The applicable law. You're buying from China, you're buying from America, you're buying from other countries around. Which is the applicable law for you? Payment terms, delivery terms, Incoterms I'm talking around, the warranties, express warranty, implied warranties, there could be many things. Liquidated damages, social responsibilities, quantity, price, terminations, force measures, source code, those who are dealing with source code escrow accounts, you know very well, the software part, claims, copyrights, limitations, remedies, insurance, indemnification. In my life, I've always heard around, this used to be a very tough issue, indemnification. And coming under right to subcontract, royalties, intellectual property right, IPR, and arbitration. They're broad ones, but let me walk through quick few ones. Insurance and indemnifications, very crucial. You should try to indemnify yourself, your organization, hold harmless. The guy might have stolen something and giving it to you. Later on the police comes, guys, this is a stolen product you bought from them. So you need the product safety, you need product liability, product infringements. All those things you have to ensure that you are indemnified. And the guy has to supply, if they want to do insurance, they can do it. But you don't want to get into those hassles around. So keep in mind, your terms and conditions protects you. Intellectual property rights. You might be sharing many terms, conditions, projects, detail. You don't want those project detail being passed on to someone. You might have done some beautiful design, which is your patent. You are asking someone to do it for you. So you're giving a sole right to use, but then it should not be passed on to others. Royalties, payment for use of patents, copyrights. So royalty is also part of it. Like in ISM, we use some of the material from our headquarters, so we pay royalties for that. So royalties have to be paid. Consent to the subcontract. So consent to the subcontract means you've taken a business from me, then you're passing on to someone tier 1, tier 2, and you need to take the approval from me, the whom you're giving it. That company whom you subcontract may not be to the standard of us in terms of social responsibility. Might be hiring some kids around, might be slaving them. So you have to be sure whom they are subcontracting. Applicable law. This is one I will touch it on. United Nations Convention on Contract for Sale of Goods. This is purely for the goods. CISG. This was set up by UN. For those, there are around 65 countries who have agreed for this. India is one of them. If you're supplying goods to those countries which are part of the convention, you can make CISG as an applicable law. It's a global law. Terminations, exit clauses. Sometimes you want to, for some reason you want to terminate, for convenience. You always will find in all the boilerplates, you will find termination for convenience. Customer confidentiality, signing of non-disclosure agreements, force majeure to protect against terrorism, assignment provisions, source codes. All of you know those who are dealing with the software. Because nobody gives you ownership of the licensing agreement. But they give you source code in case the company closed down, you can access the source code. Protest. If supplier feel they are not being fairly treated, the price was too low, they were hammered on them, they could come back with a hearing. Claims, right to claim, right to payments, or poor performance, you also have a right. If the guy has done a bad job, poor performance, certainly, then you have a right. Limitation of liability. I know in some company they'll say liability is around millions of dollars, which may be even 20 times, 30 times than the size of the contract. So this is where the supplier will come to you, sorry, my contract is of only $500,000 and you're making the liability of $10 million. This is not fair. So that I think negotiation has to be done. Consequential damages. The guy delays it. And that delay could affect your business further. Collusive offers. It could happen. Since I've been dealing in the UN with many suppliers worldwide, suppliers collude together. So that collusion has to be the secret agreement they have made around suspensions. The clause is to protect against unforeseen funding. Terms and conditions again, reservation of right. Estoppel means if you have made the promise, even orally, it must be reinforced. I know it's very difficult to prove whether you have said this way or that way, but this is the problem with that comes under. Estoppel makes this. Social responsibility issues, we all know very well, worker safety, environmental issues, state of domains, which jurisdiction will apply around, which law will apply. Liquidated damages, this is a must, I would say, for all your contract where delivery is the essence of the contract, please do include liquidated damages as part of it. The lawyers cannot tell you, you have to tell, I want this clause must. Amount, you can spell it out. Warranties could be express, implied. You don't have to write everything around. About the quality, certainly you'll write to express around, but then there are something which has to be good. You're buying a food. It has to be fit for use. So those are the one implied warranty. You don't have to write each and every word. Those are understood by the law that you will be giving some food items to us which is fit for use. I don't have to write all these words. This is understood. Performance of the contract. You have asked somebody to give me 30 generators by this time, 200 computers by this time. You have asked somebody for service contract. I want training to be done within these days. Doesn't happen. Or the quality is so poor, the people are not very happy. That means you are basically breaching the contract. And this gives rise to remedies to non-breaching. One is breaching, one is non-breaching. It could be anyone, could be supplier or buyer. The one who is breaching it, if you terminate the contract, you're breaching it. Other is a non-breaching, they can ask for the claims. Similarly, the supplier has given you poor performance. You're the non-breaching, you could ask for the remedies. Now, partial breach could be, sometimes breach could be partial, sometimes could be big ones. Partial could be, the guy was supposed to give you 20 generators, but gave you 19. One was missing. There's a breach. But can I call as a material breach, or should I call immaterial breach? If it is immaterial, it's a different approach. If it's a material breach, certainly you can terminate. But if it's immaterial, can I terminate the contract, or do I need a different approach around? So keep in mind acceptance and rejection of the goods. You get the goods, you accepted it. But that acceptance is different than the receipt. You might have received the good, but receipt does not mean acceptance. Acceptance is legally more, in the legal act, indicate the buyer acknowledges the receipt of goods and confirm to the contract. So keep in mind, the receipt word, I have received the goods. But when you say receive, it does not mean it is conforming to the contract. Acceptance means you are saying whatever goods you have received, you are acknowledging it, they conform to the contract. If inspection discloses any variance, it could happen. You can reject the whole, accept few if you are real much in need of it, and reject the rest one. Sometimes it also can happen that you have already got the goods, you have accepted it, but when you try to fit it, then you say, guys, my goodness, this is not correct. In those situations, because you have discovered the defect after acceptance, you can certainly go back, but within the particular time frame. Not that you accept the goods and keep it for 6 months, then you say, guys, oh, I'm not happy with this. There's a particular time frame in a month or 2 months. So even if you're spelled out in your contracts, wonderful. If not, so within a month, you have to go back. You can't go much later. Next comes dispute resolutions. The dispute could be due to rejection. You're doing rejection on the goods. Obviously, when you're rejecting, supplier is not going to take it lightly. First thing, they will try to convince you. Then it could lead to litigation if it's a big amount. And the statute of limitation is there's a time period during which party may seek to enforce this right. I mean, you can't again delay it for a long and come with a dispute after 2 years. If the performance is poor, go back for litigation in a very immediate time. So the breach by procurement organizations, breach by the supplier could happen, failure to deliver, delivering of goods which are not conforming. You ask for some product which are X specification and the guy gives you Y specifications. They're not matching. It's a non-conforming goods. So the remedy is, obviously one is to give you compensatory damages. Another remedy like damage, your image might have been tarnished in those cases, but again, it's an exceptional cases. Now comes to the remedies. Very clear, one heading you find in a very bold form is cure. You bought something, they are not good, the guy comes down to your place, fixes them, makes the situation right, puts them back into the normal shape. Second could be that, guys, it can't be cured. Then you will say, guys, because you asked something to be made of stainless steel 304, and the guy has given you of iron steel. So naturally, this can't be cured. It has to be destroyed totally. Cover, that means the guy has to give you compensation. Protect you by giving compensation against the breach. And that compensation could be more than the amount of the contract, because now you have to go to the second supplier whose price may be more, and in the process you have lost some timing. Incidental damages, there could be expenses incurred in receipt, transportation, inspections, all those things are part of this. General damages flow from breach and can be identified. But then general damages, if you want to talk around, that means you say, guys, if I don't receive by this within the 2 days, those type of damages, you must put them in advance. Tell the guy in advance. If I don't see by this time, you will be penalized for this. I won't pay this. Now comes consequential and actual damages. These include lost profits, certainly, because you are supposed to get the goods and deliver to someone. Now the delivery cycle has delayed, your image has been damaged, and maybe next time you may not get a business. So that consequential damages also need to be remedied. Now comes to alternate dispute resolution. One is the dispute resolution by going in the court. So court proceedings, all of you know, are very adversarial, time consuming, and in the process, once you go to the court, your relationship is destroyed. You will never do business with that supplier, and supplier will also try to avoid you. So if parties can resolve themselves, so what we can do? We can do mediations. We get some third party who is known to both of us, who is a well-known person, a person of knowledge, person of trust, and the guy tries to mediate between you. But keep in mind, This guide decision may not be binding. Similarly, conciliation. Conciliation is only trying to arrange the meeting of the two. You guys are not even on the talking terms. Somebody says, guy, let me conciliate. But you have to find your own solutions. The guy conciliates, say, guys, come to my house, meet, I'll serve you coffee, tea, but then you have to find the solution. That's a conciliation. In your personal life, you use a lot. Arbitration. Here you have an arbitrator. There are arbitration guidelines. Normally, UNCITRAL has developed the United Nations Commission of International Trade Law, UNCITRAL. They have developed their own guideline, which are used universally. Since I work with Dell, Flextronics, and all those companies around, everyone uses UNCITRAL. And for the applicable law, some will use CISG. If not, then they may use some other law. But again, it has to be explained what law the arbitrator will follow. CISG, I think I have explained quite a lot already. This is again from the Convention of the United Nations. So this is, again, those people who have ratified this. So far, only 65 countries have ratified CISG. So within those countries, as I said to you, India is part of it. You can use this as a backup for the applicable law. Next come the types of contract. You have a fixed price contract. You all know very well. You could have a price with escalation factors, particularly when the contract is of longer duration. Civil works, steel price may go up, cement may go up. You have escalation factors. Or you may say, guys, okay, let's start, and then we'll redetermine the price if there are variables with changes. Another one is a cost-based contract. So I will pay you whatever it costs you. If I have to give a contract for R&D activities to IIT, they will expect me not the fixed price. They'll say, guys, whatever is going to cost me, my salaries of the staff, people, experts, you will have to pay. But then to protect yourself, that you don't get a surprising amount, you put down a threshold. You will certainly pay for the cost, but this threshold will be this. You put down a ceiling around. So whichever is the lower, you pay for it. Again, there are letters contracts. Sometimes you form of a letter. The way name indicates, you authorize someone, guys, go ahead, do it. You make dealers agreements, service agreements. Because those who are dealing with services, non-professional services like maintenance services, are professional service agreements for legal audit, master service agreements, performance-based agreements, which you all are very aware of this service level agreement. You say, guys, if you're giving a contract for internet connection, you'll say, guys, downtime should not be more than this. If it is more, I'm going to penalize you. So you make the service quality as one of the parameters, or service performance as one of the parameters. Licensing agreements, master purchase agreements, particularly for MROs, maintenance items, office supplies. You make a one-year contract with one supplier. You negotiate for the whole years. Whenever the need comes, send a quick email, the guy delivers you. Construction contract, you know very well. In addition, I'm sure those of you dealing with turnkey projects, they may have a different format of contract. There are dozens of varieties of contracts formed. Contract can be void, contract can be express, contract can be employed. A void contract that has no legal effect at all, it's a void contract. For some reasons, because the guy didn't do the job, didn't start the work before time, the contract has become void. You told him, I want this delivery to be done by end of March, the guy has not even come back to you, and now starts working in April, the contract is void. Express means you have expressed someone. You could say A tells B on phone that he wants to buy his car for rupees 80,000 and accepts the offer on phone. So this contract is an express contract. And sometimes could be in employees on the stations, railway stations, you find prices are spelled out, a coolie in uniform takes up the luggage. of B at railway stations, then the law implies that B will have to pay for the service they pay. It's an implied contract. So like this it is there. But keep in mind when you're drafting the contract, I know many of you know it, use the right language. Specifically, I'm putting the word on shall or will. Shall is more legally binding, the term. Will is not. So when you're writing on behalf of the supplier, then you have to mention you shall do this. Your own company, when it has to do around, use the word will. Don't make company as a legally binding and supplier to have fun. So keep in mind, X shall pay, Y shall wash, will pay. So will and shall has a difference around. Now comes negotiation part. So naturally when you understood the contract, terms, condition, but they cannot be finalized without negotiation. I'm not talking of the low value contracts. The contract which are bigger amounts, negotiation is part of. Now there's a need to negotiate before you draft the final contract. The purpose is to reach to an agreement. So when we talk of negotiation, the need for negotiation comes because there's a gap. There's a gap between the two, and you want to negotiate. And I'm sure you all are smart in negotiations. And particularly in India, we learn from the childhood to negotiate with the mother. After marriage, negotiate with the wife, negotiate with the kids, negotiate with the three-wheelers. So we are all used to negotiation. So negotiation is built in our DNA, I would call around. As a general Indian, I think normally people say they're very good on negotiations. So negotiation, when I talk around, is the art of reaching an agreement by resolving the differences through creativity. It is not just hammering on the price, saying, guys, okay, if you cut down this, I'll get you long-term business, I'll get you this. The creativity is very important around. There's a gap, and that's the gap you're trying to bridge this gap around. Again, some people think they're born as a good negotiator. Yes, I know to some extent correct, but in India, but I would say these skills can be developed. If you're given the chance, you're given the opportunity to negotiate big contract, you learn the game better. Now, when I talk of negotiation, I think as I said to you in the beginning, we all do it. It's a way of life in India at least. I would say many developing countries, it's a way of life. When I used to stay in the US, it was not very common, but in India, it's very common. See, if you look at this, it's always me and you word. If you look in the one corner, me is standing one corner, you is standing other side, there's no common ground. When there's no common ground, the negotiation will not lead to anything. If you look at the center one, the me and you, there is something commonality. That commonality could be because you went to the same college. You both like cricket. Something is common and you can talk around. It brings you together. And the last one is you are in total agreement. So when you're in agreement to each other's, why negotiate them? So basically you're looking for a scenario where there is an opportunity to have some linkage, something commonality. You need them, they need you. There is something common interest. In the first case, they say, I don't care for this. If they want, let them come to me. You also says, if they want, let them come to me. There's no common ground. This is very important now before you really start negotiating. You negotiate with someone, the guy is not interested. You're wasting your time. There has to be common ground. So negotiation objective is what do we want to achieve? We want to reach fair and reasonable price. We don't want to hammer on someone to go such a low price because the guy is in real need of it. In those situations, the guy may accept the contract, but later on, if they get some other alternative, will ditch you. So objective should be reasonable price, timely performance. If you know very well the job cannot be done in 24 hours, you're wasting your time. If it needs 48 hours, let it be 48 hours. Meeting the needs of the organization. control over how the contract is performed, minimum supplier cooperations, sound relation with suppliers. Sometimes you're not looking for one-time relationship that you got the best price. You also want supplier to feel comfortable. I met this Mr. X or Miss Y. They are wonderful procurement people. I want to deal with them on a regular basis. You call them and they say, hi, come on, let's discuss. But once they've done a bad experience, they'll keep you distance. So keep in mind the future relationship is equally important. Here I'll just walk through the broad steps around. The very first step is persuade. I think persuasion goes a long way. Let's say you have 20 suppliers sitting in front of you. You give an understanding about your company. You say, guys, I'm from company X. Our business is so much. We are growing leaps and bounds. Those of you who do a good business with us, they will stay with us. So in the process, you have set the scene. If I'm a supplier, I listen to you. I say, guys, this company is wonderful. I should certainly do business with them. Maybe my future business is assured. The persuasion, clearing in the mind of others that this is a great company to work with. Simple logic does not work. Some people are like a logistician type. Okay, guys, here 2 plus 2. The guy is trying to explain, oh, my cost of raw material was this was this, fine. It does not become sometimes persuasive. Giving a bigger pictures, taking understanding of the company, and argumentative. Don't get into arguments. The more you argument, the whole negotiation dilutes. It does not work at all. Effective persuasion. Average persuader give things away to each event. If I come to your company and then you tell me, Krishan, this is what is our plans, and we are thinking of this. If this works out very well, we are thinking to work with you on this. So mentally you have made my mind biased. You have persuaded me. So I'm willing to listen to you then. You have to find the areas to use your levers. The levers could be that you are a very top-notch person. Supplier knows very well whatever this guy says is the final. So those are one of the levers. You are the top company in India. Everybody wants to work with you. You are a big name. Everybody wants to be associated with you. So that's the levers you have to use around. You may need to investigate the negotiating. You have to do the homework. Just don't jump into the negotiation without doing homework. Who is on the stronger footing? Is the supplier on the stronger footing? Are you on the stronger footing? Trade concessions. Don't give them away. You are doing concession mean if you give something, get something for that. So don't give concession, I'm saying trade concessions. So the word is trade concession. Remember, win is not 50-50. The pie is not fixed. It's not like a cake. If I've eaten 60%, you are left with 40%. It's not that. So the pie can be expanded. So it is not a zero-sum game. Never forget that no deal is better than a bad deal. If you're going to make it just for the sake of a bad deal and deal is bad, I'll better say don't make it. So when we talk of negotiations, effective negotiations, 3 areas are very, very important to make you powerful. Preparation is very important. Planning, strategies, tactics. You have to make a strategy, bigger pictures. What is the game plan? Like a chess game. So when any one of you plays a chess game, they know very well what strategies to follow, what tactics to do. And lastly is face-to-face skill. It's very important around. So when you're sitting face-to-face, the guy has quoted you price X, you go with a Y and then you look at the face of the other guy, what reaction the guy is. If the guy is cool, is not affecting, that means the guy is willing to. But if the guy is very frowning, that means the price what you're quoting is not acceptable. So reading the faces, human bodies, I think his body knowledge is very important. The body skill, understanding the body language is very important. So this combination will make you effective. Preparations, strategies, tactics, and the body language. So negotiation philosophies, I think you all know very well, win-win situation. We work as a partner, we work as a cooperation. Win-lose, guys, I want competition, I want to hammer down. I want best for my company. My concern is for my company, not for the supplier. But in the lose-lose, neither you have a concern for your own company, supplier also has no concern for their own company. So no low degree of concern for each other. This is, guys, go to hell, I'm not interested. Buyer also thinks same way, supplier also thinks same way. So in the process, it's a purely confrontation. So the desire is to go for win-win, wherever feasible. In some areas, you will like to go for win-lose also, the competitive part. The critical step when it comes to preparation for negotiation is planning. Looking at the SWOT analysis for the supplier. What is the strength? You will see its extra T here around. Strength, weakness, opportunity, threats, and they're also saying trends in the market. What changes are happening around. And the Portal 5 Forces is a wonderful tool. All of you should try to know it. The threat of entrants, the threat of substitute. The guys, new products are coming around in the market. You are the only buyer in the market. Naturally, then you are the strongest, the power of the buyer is there. But if the supplier is supplying to many of your competitors, and to you they only supply maybe 2% of their business, they're not very powerful. Supplier is powerful. So first step is to conduct in-depth analysis of supplier proposal. That is the price, what they're paying, quoting it, delivery, what they're quoting it, specification, they're quoting it. So next step in negotiation plan is to set objectives. So once you've done the homework, then set down your objectives. What is the target price you want to achieve? The target delivery you want to achieve. Set down the objective. Just before you go face-to-face negotiation or even electronic negotiation, virtual negotiation. Next, the party should drop a specific plan. And actually, for doing negotiation, it is never done by one person. So you need a team leader. Team has to be there. As far as possible, it's to be cross-functional. Sometimes this question comes, where should we conduct them? The best is to conduct at your location, as a buyer location. It makes you powerful. Team selection should be always cross-functional team. Don't take the bunch of your own people from your own department. And you are the boss of them, they will all say, yes, sir. So try to make a cross-functional team. Try to analyze the seller position. Try to analyze your own position. Do the cross-price analysis in some situations where there's only monopoly of a supplier. You may like to do the cross-price analysis. Should we make it ourselves? Or should you only depend on this guy because this guy is dictating too much? So you need to work on that. Strategies and tactics. As I said to you, very simple is an overall approach, is game plan for conducting the negotiation and tactics of particular action to achieve that. So it's a maneuver part. So when it comes to negotiation strategies, you own your own negotiation objectives, what you want, what is the interest of yours, and the interest of other side also. Relative strength of both, weakness of both. So once you got the combination of all this, then you are able to make the negotiation strategy. Tactics are many, hundreds of them, but I've just written on a few of them. The very question is that you have to ask the right question, open questions. Let the guy come and give answer to you. Try to be good listener also. Use solid data. Sometimes silence is gold. When you are feeling the guy is not listening to you, the guy's prices are very high, the moment you sit down silent, it makes the other party nervous. The guy is speaking and you're not even bothering around it. You're so silent, the guy gets confused that something is wrong. Either my prices are too high, my terms and conditions are not acceptable. So that is one type of tactics to create that, guys, I'm not happy with what you're giving me. There's another one called caucuses. Caucuses means you say, guys, now we have been discussing for last half an hour. We're repeating the same word again and again. You'll say, guys, okay, guys, let's have a break for coffee, tea. Then you go down separately in your room and then you say, guys, let's make a new strategy with your team. How we want. What role each will play. You want to be bad cop, good cop, all those strategies, you have to work it out. So don't be afraid to say no. Beware of deadline. So keep in mind, be aware of the body language, legs, facial expressions. Sometimes the problem comes with the sole supplier. Most difficult thing is sole supplier. So there are many ways to do it. I would say with the sole supplier, several tactics can help. Documentation of, the way I would look around in a simple word, looking at the time frame. Sole supplier means either you have some alternate solutions, find that, or you feel that this supplier is taking you for a ride and you want to make it in-house. So there are many choices around. Or try to move with the guy, try to make a partnership with the guy. So there are many solutions around. Documentation of the negotiation. Whatever you have discussed, you must document it. Now the negotiation, you could do it as a consortium. Like there are 20 hospitals around, you have a consortium of them. So you sit down as a next consortium and do the negotiations. Or cooperatives. Or you might be doing negotiation on behalf of, let's say, 20 hospitals, they buy many things around. You are the cooperative, you buy, you make the negotiation, you do everything, and those hospitals can make use of those prices. So co-ops serves, this is a very growing business nowadays, the cooperatives, because you are able to pool, you are able to leverage the requirements of many hospitals. I know many people, they come and meet me, Krishna, I'm starting this business. I'm trying to consolidate the requirements of universities, hotels, and trying to negotiate the best price and passing on the same prices to them. Next comes the bargaining part. When you're doing the bargaining, define your range, start, target, walkaway price. You have a starting price. Like you and me, when we do the shopping, you have a start price. But mind, you have a target price where you want to achieve. And walkaway is the one, if the guy does not come to that level, you'll say, guys, bye-bye, I'm walking away. You'll say, guys, I'm going to the next shop. So then you have an alternative also. So BATNA is the best alternative. Then there could be BATNA is the worst alternative. So those are there around. You have a negotiation zones. The buyer says, guys, okay, I'll be very happy if I get for $10. I'll be in a bad mood if I'm not able to get 15 is the worst scenarios. Or after 15, I'll walk away. So my target price could be between 10 and 15, let's say 12 or 13, my target price. Seller is saying, guys, if I can sell at 17, I'm very happy, I made my day. If I sell at 11, I'm losing. That means less than 11, I will be walk away. I'll say, sorry, I don't want to work with you. The target price of this guy could be around 13 or 14. Buyer also could be 13, 14. So maybe the target could match around. But how do we know each other's when is going to be smiling and when is not going to be smiling? That target part is the, I think you have to learn with experience around. So the BATNA is again best alternative to a negotiated agreement. You have done negotiation agreement, but then you know very well I have another choice. And that choice you don't want to go because it's the first time experiment. But that choice price is better than this, you may go with that. But the least damaging outcome anticipated if no agreement is reached. So BATNA is the worst alternative. That means if I don't make a deal now, I have no choice. My alternative is worse than this. So this is where the situation comes in. The body language, very crucial. What you say, how we say, and how we. I've been moving around 75, 80 countries around. I have seen everywhere the way we speak, the way of the guy that understands around, how our look looks like, the type of signals we pass on, when we nod our heads, how they understand it. Are we saying yes or no? Everything changes around. So try to understand the body language, understand the culture of the other countries around, other nationalities around. Even within India also we have to learn the culture from one to another states around before we do any business with anyone. Well, friend, with this, I want to thank you all for the patient hearing, and I'm very happy that you were able to